There are those who believe that the Supreme Court's decision is a landmark judgment as it puts a definite time frame on when sanction for prosecution must be given. There are others who feel that the courts have overreached and it's an unimplementable decision. Joining us now, he's smiling away to glory, Dr. Subramanian Swamy, man of the match as it were. He's come out, he's taken on the government, he's come out victorious. Thank you very much, sir, for joining us. I also want to introduce Vineet Narayan, senior journalist. It was his case that was cited in the Supreme Court. Thank you very much, sir. Aman Lekhi, senior advocate, has got some issues with the Supreme Court's decision today. We've also got with us Sudhir Kumar, former commissioner of the Central Vigilance Commission. With us at this time, national spokesperson for the BJP, member of Parliament, Chandan Mitra. We've also got Sanjay Jha from HamaraCongress.com. I want to begin by understanding from Subramanian Swamy on what several people are saying is an overreach by the judiciary. They believe that you can't put a sword over the government and say that you must decide within 4 months. This is administratively very difficult to implement. That's what people have been ringing up various journalists, and that's the message the government wants to give this year.
Well, it's not a new time limit. The Vineet Narayan case already has it. Justice Verma had said it, and this Chief Vigilance Commissioner has put it on his website, the guidelines for sanction, and he has said very clearly it should not take more than 3 months. This 4 months is that extra month in case you want to consult the Attorney General. I would think that, you see, first of all, let me say that nobody needs nearly more than 10 days to decide whether after all, what is the sanction for? To decide whether it is a prima facie case in the appreciation of the sanctioning authority. And he has to decide on the material presented. He has to do no inquiry at all. He has to not ask anybody. Now, in my case, of course, the Prime Minister sent it to Raja also to ask his opinion. He has sent it to the CBI and so on. So those are all not allowed under the rules for sanction. But the real question is that if you can't decide in 10 days, 4 months is a lot of time.
Sudhir Kumar has been with the Central Vigilance Commission. He feels that this decision is not implementable. Can you explain to viewers who would want decisions to be taken by the government immediately? 10 days, 4 months sounds like a reasonable period. Why do you, sir, with your experience, feel that the decision is not a good idea?
No, I don't say that it is not implementable. In fact, what Dr. Swamy has said, there are already instructions, guidelines there on record, but they are administrative guidelines suggesting that the cases must be decided within 3 to 4 months for according sanction of for prosecution by the competent authority. And there are also steps laid down for resolving issues if there is disagreement between the sanctioning authority and...
But that's clearly not working, because we have some figures over here.
Yes.
Of the 319 requests for sanction, 126 requests, sanction is awaited. So the government is sitting on the request for sanction. That's what Subramanian Swamy has been said, which is why this decision is being hailed across the country.
Yes, there are large number of cases which are pending this sanction. And it's very difficult to hold anybody accountable for that.
Aman Lekhi has some problems with the decision as well. Explain to our viewers what your problems are and why you think this could be a case of judicial overreach.
No, I will not say the case of judicial overreach. I mean, I'll qualify that. The question is that we have proceeding litigants like Mr. Swamy, you've got activist judges. Why? Because we are responding to what is actually inept governance. Now, ideally, if the executive expedited whatever it's supposed to do theoretically, and the legislature was alive to the omission by the executive by having a law to deal with that particular omission, the occasion for the interference by the Supreme Court or court at all would not arise. But the courts are interfering because there is a failure insofar as the executive and legislature both are concerned. That said, while this judgment is absolutely unacceptable in the facts and the political environment as it stands today, because the message has to go that corruption is something, it is intolerable. The issue is that when the judiciary starts laying down the law, now, while adjudicating a matter, it can be specific to the facts of the case. In this particular case, what happens is the issue of deemed sanction. The deemed sanction by its very nature deals with application of mind. Now, the problem with deemed sanction would be if in a particular case, the case is not one of sanction, but the person in charge wants to harass another official. In that event, he'll just sit on the file, and the person is actually liable to have the protection of law enforced, would by reason of deemed sanction be prosecuted. So that will actually negate the whole purpose behind